presentation, but there's going to be lots of opportunities to engage during today's session. You're already doing so in the chat, so thank you for that. If you have questions pertaining to the content today, you can type them into the chat box. You can enter them into the Q&A box. I'll be here the whole time, making sure that your questions get addressed, making sure that we are able to, maybe we can stump Eli today. We'll see. It's hard to do, but you can submit your questions at any time and we'll make sure that those get answered. I will say though, if you have any very specific employee issues, we encourage you to reach out on that HR hotline, which you'll see in a second. It's also in your handouts. Or to reach out to an attorney directly. If you go to our website under partners, we have some really great partner attorneys that we work with if you have anything really specific that you need some advice on. Handouts for this training, those were sent out in yesterday's reminder email. We were alerted to a correction that needed to be made. So what I'm going to do is drop the corrected PDF into the chat. I'll drop it now. I'll drop it also at the end. And then if there's any problem accessing that PDF, go ahead and ping me in the chat and I'll make sure that you get that one way or another, okay? Last but not least, we have a survey. So at the end, you'll see a slide with a QR code. I'll also drop a hyperlink into the chat and it goes to a very quick survey. It's 5 questions. They're all multiple choice. It takes less than a minute to complete, but the feedback that you share with us, we then share with our partners over at Ventura County. And collectively, we all make sure that we are trying to meet and hopefully exceed your expectations with trainings like these, as well as our entire suite of resources for employers. So if you can help us with that 1 minute, less than 5 questions, less than a minute, we would really appreciate that help. So as I mentioned, today's training is sponsored by our partners over at Ventura. Today we have Roxana Gamboa, Business Solutions Specialist, who's here to share more about those resources available to you.
Good morning, everyone. My name is Roxana Gamboa, and thank you so much, Anna, for the introduction. I am a Business Solutions Specialist with the Ventura County Workforce Development Board, and some of the services that we provide are, for example, the HR hotline that we have available at no cost to our employers of Ventura County. And you can call the number that's listed on the screen. And you can call with your HR questions Monday through Friday from 8 to 5. Some of the other services that we offer are job fairs. We do virtual and in person. We do virtual hiring board, HR hotline, webinars like the one that we are in today. And then we also provide some rapid response, which is businesses that are at the verge of laying off people. We can help with preventing layoffs. We also can upskill your current employees. We can provide current training and placement of employees who have been laid off if it were to get to that point. We would like your contact information to continue to provide you with trainings such as the one that we're on today, and that is for the funding so that we can continue to secure the funding. Thank you for providing your contact information, and if you would like, I can also provide you with a copy of our Business Solutions book that will detail all of our services that we have available at no cost to our employers in Ventura County. And if you would like a copy of that, I can go ahead and send it to you. I will also include my contact information, and if you have any questions or you would like for me to contact you regarding our services, I would be more than happy to, and I will drop my information in the chat. Thank you, and thank you for joining us.
All right, thank you, Roxana, Cynthia, Colleen, the whole team over at Ventura County for bringing this webinar to you all today. So now I have the great privilege of introducing our trainer today. We have Eli Nunez, one of our amazing HR directors. If you've called into that hotline, maybe you have had the pleasure of working with him, but I know we have so much to cover, and so it is all yours, Eli.
Thank you, Anna. Thank you for the introduction. I'll try to live up to the amazing name here. I don't know if I can. And thank you, Roxana, and everybody else at the Ventura County Workforce Development Board. Always a pleasure working with you and presenting for Ventura County. And I would urge everybody to please contact them and get those resources from them. I mean, you know, as business owners, we know that things can get a little tough sometimes. So any little bit of help we can get works out. So reach out to Roxana and make sure you get that information from her. So I'd also like to remind you of the hotline once again, 888-763-3174. You can reach out to us Monday through Friday, 8 to 5, with any questions, whether it's regarding this webinar we're on today or anything else HR related. Please reach out to us, or even if you just have a situation that you just need to talk through, right? We know that those HR issues that pop up aren't always easy. They're not always simple. Sometimes you just need to talk them out with somebody. Give us a call. We'd love to hear from you. Love to help out in any way that we can. Speaking of we, who are we? We are California Employers Association, of which I am one of the HR directors here, and our goal is to provide peace of mind to all our callers, to our partners, anybody that reaches out to us for help. We try to provide peace of mind. As I said, we know HR, human resources can be complicated, so we're here to help. We provide training such as this, quick responses to your questions. We also have handbook services, among other things as well. So rest assured, any question that you have, anything you need to talk about regarding human resources, we are here for you. Having said that, though, one thing I must let you know of is that we are not lawyers. And even though we do have people on our team with legal experience, we do not provide legal advice. And this presentation itself should be taken as educational and not as legal advice. Again, even though we'll be touching on some topics of a legal nature, state laws, regulations, that sort of thing, we do urge you, if you have any questions, legal questions of significance to you, please reach out to legal counsel. If you have one you work with, let them know. Otherwise, come to our page, employers.org. We do have some partners that we work with that are, specialized in employer topics. So again, this is the fine print section. We're not lawyers. If you have any questions of legal nature, please consult your attorney. With that, let's jump right into what we're going to talk about today. As you know, it's the top 10 ways to stay out of court. So what things we'll cover today is basically the employment relationship, the best ways to start it and to end it. Because, relationships one way or another, they will have a beginning, they will have an ending. Whether it's a separation, termination, somebody leaves, or retirement, whatever it is, it's important to make sure that we are starting off on the right foot and closing things off correctly to avoid any issues. Policies and employee handbooks, we're going to talk about the importance of that, how important it is to make sure that they're current and compliant with all laws and changes in California. And as you know, if you've been to any of our webinars or labor law updates, I mean, things change pretty quickly in California. Change comes fast and furious, whether it's the beginning of the year or the end or in the middle sometimes. So it's important to make sure that our policies and our handbook are up to date. Meal and rest period violations continue to be, continue to catch employers sometimes. Sometimes we don't always get it right. So it's important to make sure that we're avoiding those meal and rest period violations, as well as misclassifying employees. Misclassification can mean that we're not paying them correctly, which of course means a lot of waiting time penalties and other types of things that we're responsible for. So again, that's avoiding those is very important. And finally, harassment issues. It's important as employers to be very proactive in how we address and prevent any harassment or discrimination issues in the workplace. So again, some of these top 10 tips that we'll talk about, or top 10 ways, will address being proactive and staying ahead of issues or dealing with them early on so they don't become impossible or even more difficult for us to deal with. So with that, we'll go ahead and start with number 10. Now keep in mind, these are, not in order of most important, least important or anything. It's just 10 things that we've identified throughout our years and through our interactions with callers and members as things to address to stay out of court. And the first one, of course, it makes sense to number 10 to start with our hiring practices. Now, here at CA, we like to say that you should hire slow and fire fast. And we'll get to what fire fast means here in a minute, but hiring slow basically means taking your time when when we find ourselves in need of expanding our team or replacing somebody, right? So again, that means taking our time with things with a new hire orientation. How we onboard somebody is so important to their longevity, right? We want to make sure that when we're onboarding somebody or bringing them on or going through the orientation, that it's kind of giving them a good picture of what the organization is, that it's helping them to become a part of the organization rather than just throwing a stack of papers at them and walking out of the room. Another important thing too during that orientation is making sure that we're going through all our policies, all our handbooks with them, setting those expectations early on. So again, it's not just a matter of handing them the handbook and having them sign for it and expecting them to follow it, right? We want to make sure that there's discussion for it and that there's understanding of what's in there on their part. It's not just a matter of hot potato or serving them with a handbook, right? We want to make sure that they understand what is expected of them, and that they're signing for it, signing that acknowledgement saying, yes, I received all these policies, this handbook, I understand, and I agree to abide by them, and I understand what will happen if I don't abide by these policies. Again, we don't want there to be any surprises down the road if there has to be any kind of corrective action as well. And of course, California is an at-will state, so it's important that we um, reinforce that early on, or that we draw attention to it early on, whether it's in the offer letter or having that clause in our handbook as well is equally important, just so that employees are reminded that, hey, they can leave at any time for any reason, and their employment can be terminated at any time for any legal reason as well. Now, a little bit more on hiring slow. And really, hiring slow doesn't just begin on the first day of the employee's work when they come into your office for the very first day. Hiring slow really means we understand what we need. We're taking our time to know that we're getting the right person or filling the position correctly. And again, I think we've been in situations, I've personally been in situations where the organization I was with just, the managers just wanted somebody there. They basically just wanted a body to fill the slot, right? And if you've been doing human resources for more than a day or two, you know that just throwing bodies in there could be a never-ending cycle. Sometimes you get lucky and you get the right person in there, but most of the time, if you're just throwing bodies at the work, you're gonna find yourself in a constant cycle of replacement, right? Because you didn't really identify what the work was, what the qualifications were, and take the time to explain to that person or to update the job description, say, this is what the job looks like, so, this is what they have to be ready for. Again, I talked about that employment relationship. It's just like any other relationship, right? We want to make sure that we have some disclosure in the beginning so that the person knows what they're getting into, that being our candidate, and so that we know what we're getting when we're hiring somebody. So once you identify, what you need, what kind of a person we need, is this a full-time or a part-time position? Is just a replacement? The next step usually is bringing people in, talking to them to make sure that they are the right person. Those interviews, right? Very important part of it, whether it's face-to-face, over Zoom, over the phone, whatever it is, it's very important because, you really get that back and forth communication with somebody. And with that communication, of course, comes a chance for us to possibly make mistakes or ask the wrong questions. So it's very important to know what questions or what areas we want to avoid when we're talking to a candidate. Some of these are easy, right? We know that we don't want to ask about age or family status or race, religion, anything like that, right? And I would encourage you, even conversationally, that's not something that you want to bring up, even if you're just walking them, back from the lobby to the interview office or walking them out. Try to avoid those questions just because you don't want to give the impression that those answers had anything to do with the decision to hire or to not hire. So again, very important to avoid those topics. In California too, we cannot ask about salary history. And if you've been around for a bit like I have, you can remember that sometimes in job applications, it would ask, where did you work? How much were you paid? What was your compensation there? That should no longer be a part of job applications. That should not be a part of interview questions as well. We should not be basing any decisions based on salary history. Now, it's perfectly fine to ask somebody for their expectations. How much do they expect to make? How much would they like to make in this position? But we cannot specifically ask how much they made at their past position or at their past job. And again, this is just a move by California to try to get some pay equity in the workplace, right? We don't want people to be bound by their salary history and that prevent them from, being able to earn what the position should rightfully be paying. Criminal history, of course, asking about that is a big no-no during the interview or the application process. If you want to run a criminal background check, that should not be done until you offer the position. So again, you can conditionally offer the job as long as they perform a background check, but you cannot do that before that job is offered. So again, the important thing, during the interview, whether it's a pre-screen or an in-person interview, is you're going to focus on the job. Are the requirements of the job? How do they relate to this person's, employment history or educational history? And, you know, what are they bringing to the table? Can they actually do the job? All right, number 9, next thing that, to be knowledgeable about or to be wary of to stay out of court is leave laws, leave of absence laws. And let's see, question popped up before I move on. Can you ask if they have a criminal history? Again, I would not ask about that until you offer the position. And keep in mind that with California's restrictions too, when you're doing background checks, you can only deny a job if the conviction is directly related to the position itself. So for instance, if you're hiring a delivery driver and you run a background check and it turns out that they have multiple DUIs or driving infractions, you'd probably deny the job for that. If you're hiring a cashier and the background check turns up that they have, driving or vehicular infractions, that's not really related to the job. So that would not really be a reason to um, to deny the job. Now, as far as asking for any kind of clearance, if you are, say, a contractor that does a lot of government work, or if you work with children or things like that, and they have to get live scanned, um, that would be something maybe I would mention in the in the job posting. Again, I would not ask that, or I would not do anything about that until the job is offered. That is not something I would ask about in the interview process. All right. Let's see. And again, live scan, if you're gonna ask for a live scan, um, that's something that maybe I would mention in the job posting or the job application, let them know, hey, this is a school position, this is a position working with children. The incumbent would need to be live scanned, something very simple like that. You're not basically saying you can't have a criminal record, you're just saying this is a requirement of the job. All right. Leave of absence laws in California. Of course, California is a very protective state, very employee friendly. Um, you know, some of us have been employees at one point in our lives, so we can really appreciate that. So it's important to note, there's over 20 laws in California that offer protected leave, and each one works a little bit differently, right? Now, not all 20 or more than 20 are going to apply to you. The state does give us a little grace, if you will. They're going to apply to you based on the size of your company or your organization. So again, if you're curious about that, employers.org, we have a very nice, friendly little chart that shows you which laws apply to you based on your employment size. That's free to everybody. No need for membership to see that. So, and of course, paid sick leave, which applies to all employers in the state of California. And paid sick leave is one of those things that, we keep getting a lot of questions on. And as Anna mentioned earlier, there was a correction to our slide deck. It was on paid sick leave. So thank you for the person that found it, pointing that out to us. As of January 1st of this year, all employees are eligible for 5 days or must be given 5 days or 40 hours of paid sick leave per year, whichever is more. So what do I mean by whichever is more? That means if your employees work a 4 10-hour day schedule, they're given 5 days, which is the equivalent of 50 hours, right? So it's whatever's more between 5 days or 40 hours. Um, Now, that could be done either through an accrual process where they accrue 1 hour for every 30 hours worked, or a lump sum where you give them all 5 days or 40 hours at once. And we get a lot of questions like, hey, I have some part-time employees. Do I have to give them a full 5 days and 40 hours? If you use the lump sum method, yes. If you use the accrual method, it's just based on how many hours they work. So it is totally legal and allowed for you to have different methods for full-time employees and part-time employees. You could say our full-time employees, we're going to give them 5 days and 40 hours all at once. Our part-time employees, those that work less than 30 hours a week or whatever you want to call it, are going to accrue 1 hour for every 30 hours worked. And if they don't get the full 5 days and 40 hours a year, you're still compliant because you are using the accrual rate that the state gave us. So keep that in mind. You can have different methods for full-time versus part-time, or for, exempt versus non-exempt, or however you want to differentiate it, right? Now, paid sick leave, we don't have to pay out upon separation or termination unless it's all combined into a PTO bucket with vacation. But, well, if you have that kind of system or that kind of question, give us a call on the hotline. We can talk through that. Because if you do combine everything into one PTO policy, you have to be aware that all the protections of sick time and all the protections of vacation apply to that bucket. So it's really friendly towards the employee. And as usual, it wouldn't be California if it was just simple across the board. So in this case, if different cities, different counties do have some different ordinances as it applies to sick time. So California gives us the floor, right? They say this is the minimum you can give, but each different municipality, city, or county can go above and beyond that. And that is the case. Some cities say, okay, well, you're going to accrue at the same level as the state, but you can carry over, more, or, it's protected in different ways or what have you. So if you have any employees that work, I would say, and, take a look at San Diego, take a look at the city of Los Angeles, the Bay Area. If you have employees up in the Bay Area, Northern California, give us a call or take a look to see if there's any special protections that apply in those cases. Now, as far as, employees using paid sick leave, if if an employee asks for paid sick leave, the question we get often as someone pop up is, can we ask them for a doctor's note? We don't really recommend that because honestly, anytime you get sick doesn't always mean a doctor's visit, right? Sometimes wake up and, our kid brought home a cold from school and we know what it is, so we're just gonna stay home for the day to not get everybody sick or what have you. Asking somebody for a doctor's note every time they get sick could be seen as, putting them out or as retaliatory of them or as a way to prevent them from using their paid sick leave. So we do not recommend that you ask for a doctor's note just for paid sick leave. You can ask for doctor's documentation for any other kind of leave, CFRA, FMLA, that sort of thing, but we don't recommend that you do it for paid sick leave. And let's see, what else do we have here? If you have remote employees working in other states, if they are performing, if their home base is in those states, that's where the work's being performed, that is their place of work. Take a look at what those state laws are, because really, what applies is depending where the work is being performed, right? So, for instance, if I'll use the example of Northern California. If you have employees in the Central Valley that go out to San Francisco to perform work, be it construction, landscaping, or things like that, um, then they would be bound by the laws or the protections of where the work is being performed. So same thing with out-of-state employees. If their home base is out of state and that is where they are, then you know, look to see what the laws are there. Now, as far as paid sick leave, when it relates to construction or other industries or union industries, usually, these California protections apply. Check your contract. Check the union contract to see if there is anything differently. And again, as far as requiring doctor's notes, we would not recommend it for any usage of those 5 protected sick days. All right, moving on to our next one. Are exempt employees really exempt? That those employee exemptions are unfortunately a great way to get in trouble, right? And what I mean by exempt employees is if you have a salaried employee that doesn't earn overtime, doesn't have meals, lunch breaks, break times, that sort of thing, you have to make sure that they truly do qualify as exempt employees. It's not just a matter of an employee coming to you and say, hey, I'm going to be paid by salary. I don't want to be paid hourly. Just pay me salary. I think we've all had that conversation at one time or another that we can't do that. They have to meet the requirements to be exempt. And as you can see on the slide, I mean, misclassifying somebody can be really, really expensive. Why? Well, because if you're just paying them a flat salary and you should be paying them by the hour, maybe they're being shorted on overtime. Maybe, they're not taking their meal and rest breaks when they should. And all those things can be penalized by the state, as you can see by these examples. Now, in order for an employee to qualify as exempt, they have to meet a 2-part test. The first one is the duties test, and the second one is the salary test. So in order to be exempt, they have to make at least 2 times the state minimum wage. So you take $16 an hour, which is the minimum wage, multiply it by 2, and multiply it by 2,080 hours, which is the equivalent of a 40-hour work week for the year. That will give you the minimum of how much you should be making, unless there's certain positions like computer professionals positions, they have a different salary test, but we're talking about in general, right? So the thing to keep in mind about those exempt employees is that we're paying them for their knowledge, for their skills, for what they bring to the job. We're not paying them for the hour, for how many, for how many hours a day there are at the job, right? And you know, thing to keep in mind is, the thing about exempt employees is overtime laws. If they're truly exempt, overtime laws do not apply to them. So there is no such thing as, you know, paying overtime for exempt employees. The reason for that is that it could work both ways, right? If you're telling employees, well, this is your salary, but if you work less than 6 hours a day, it's going to go down. Technically, that's just another way of calling him an hourly employee, a non-exempt hourly employee. So again, we're paying them for the work they perform, for what they bring to the table, for their knowledge, that sort of thing, not specifically for the hours that they spend on the job or, performing work or anything like that. So again, overtime laws, meal breaks, timekeeping, clocking in and out, that generally does not apply to exempt employees. Now, when it comes to those exempt categories, um, when it comes to those exempt categories, as far as, what positions apply as exempt, uh, the most common ones are those white collar exceptions that we call them, right? The executive, that's somebody who basically manages employees, at least two employees. So it's going to be your supervisors, your managers, that sort of thing. They fall under that, or that could fall under the executive exemption or the managerial exemption, as we call it. The administrative, they work as, they work in positions that help to dealing with policies and general business operations. So think of your HR generalist, perhaps. They don't necessarily manage somebody hands-on, but their work itself, is overall management of the business. They work with policies and that sort of thing. So they could fall under that one. And finally, professional, that's anybody that has to be licensed by the state. Anybody that's licensed, think dentists, think architects, that sort of thing. They could fall under that exemption. Now, thing about exempt employees too, as I mentioned, you're paying them for the work that they do, the time that they bring to the table. So question just popped up and said, hey, if we have an exempt employee that didn't show up to work or that took 4 days off and they don't have any vacation, do we have to pay them for them? If they are taking full days away from work, you do not have to pay them for those days. And we do have a great fact sheet that you can access on our webpage that shows when you can deduct any pay away from those exempt employees. So again, if they take personal days and they did not perform any work during those days at all, you don't have to pay them for it. If they performed any work at all, though, whether it's take a phone call, send an email, that sort of thing, technically they worked for that day, so you should be paying them. So if you have a specific situation like that, give us a holler again. But yeah, usually if they miss a full day and they don't have any vacation or sick time left, you can deduct it. All right. So again, non-exempt employees, these are your hourly employees. These are your average employees. And the thing to keep in mind is in California, all employees default to non-exempt. So unless you can prove that they're exempt by having them meet that salary threshold and having them meet one of those other exemptions that I talk about, whether it's professional or executive or what have you, then they are going to default to be exempt employees. And if you have questions, about whether a position is exempt or non-exempt, go to our webpage. We do offer free worksheets that you can work through to see if the position itself is exempt or non-exempt. Again, for non-exempt or hourly employees, they're paid by the hour. They have to keep track of their time, right? One way or another, whether it's paper time cards or the electronic time clock or what have you, they are tracking their time. So, they also have to take their meal and breaks, and they are eligible for overtime. So the rules vary a little bit based on what industry you're in. So take a look at your wage order to see, if there's any nuances there as far as overtime laws or meal breaks or that sort of thing. Those wage orders should be posted over by your labor law poster or in the common area for all your employees to see. Now, when it comes to making those mistakes, if you misclassify somebody as exempt, um, and it's been going on for a bit, we always recommend talk to legal counsel, you know, and come up with a strategy as to how you're going to correct that. Because not only could, would you be owing any kind of back pay or that sort of thing, but you also want to make sure that you do something documented correctly so that it helps to protect your organization or to minimize any of the exposure there. So quick reminder for you there, what our minimum wage is, $16 an hour as of January this year. And, we'll see if it's going to increase again next year. Basically, there is a law that was signed into place back in the Jerry Brown days that says if inflation is past a certain rate, then there's an increase in minimum wage. So we'll see where we land this year. And you can see that the minimum for exempt employees is 66,560 hours per year. So that's 2 times that hourly non-exempt. And as with everything else, of course, keep an eye on those local minimum wages. They could be higher in certain counties or certain cities throughout the state. And they also make increases in those places mid-year sometimes. So, I know a lot of places had mid-year increases effective July 1st. So if you have any employees that go to those areas, and this usually applies to those that are near the minimum wage. So, landscaping, construction, that sort of thing, house cleaning, whatever it is. If you have anybody that travels to any of those localities, make sure that you're paying the right wage. So we have a nice bit.ly link there that takes you to a spreadsheet that shows what all the different local minimum wages are throughout the state. Our next one, number 7, is non-exempt employees, or relates to non-exempt or hourly employees, and that's those meal and break rests, right? Or any of those wage and hour claims. And the thing about that is there's a 3-year look back, or up to a 3-year look back period for those violations. So when you hear about, these former employees filing complaints or lawsuits or that sort of thing, a lot of times it does relates to this. They say, I was allowed to take my meal or rest break, or I wasn't paid overtime correctly, or, they'll take their wage statements over to a lawyer and there'll be something missing. So that's one of those things to make sure that we want to make sure we're getting correctly on those things, right? And something else very important too is defining what our work week is. So a lot of you may be saying, well, we work Monday through Friday. That's our work week. What I mean by work week is, when does the calendar week start for you? And again, I just, said it for you. The calendar week usually defaults to Sunday through Saturday. That's what the state, defaults it to. But if you have any kind of weird schedule or anything like that, you can change it. You can say our work week runs from Monday through Sunday or from Wednesday through Tuesday or whatever. Now that's important because that seventh consecutive day, right? That could have an effect. If you have somebody that works 7 consecutive days in the same work week, that could have an effect on how their overtime is calculated. So, pay very, very good attention to that. Usually that's defined in the handbook. We say, our work week runs from this day to that day. Now, non-exempt employees, of course, are also eligible for meal and rest breaks. Another question is, how many meal breaks or how many rest breaks do I have to give my employees? How many 10-minute breaks do I have to give them? Well, there you go. Handy chart for you showing them how many breaks, and these are just rest breaks, not meals, how many rest breaks they should receive based on how many hours they work. Does it have to be every 2 hours exactly? No, not necessarily. The state just tells us a rest break should be as close as practicable to the middle of each 4-hour work period. So again, doesn't mean that if they come in to work at 8 o'clock in the morning, at 10 o'clock they drop everything and take their break, especially if they have a line of customers or something. You can kind of fudge that back and forth a little bit. Just have it as close to the middle of that 4-hour period as possible. Now, rest breaks, there's no need for the employee to clock in or out because those rest breaks are paid. But, again, for an employee rest break, this is their time. They can do whatever they want with those net 10 minutes. So we can't say, yes, go take your break, but don't leave the facility or don't leave the office or don't leave the break room. If you do that, you're still exerting some kind of control over them and is not a true break period. Meal breaks are very similar as well. I mean, it's important, for meal and breaks, we're relieving employees of all job duties. So if they're in the position where they have to put on a bunch of safety gear or take off a bunch of safety gear, in between breaks, make sure that that time is paid and not a part of their break, right? Their meal breaks and their rest breaks have to be a net amount of time that is there. So for meal breaks, we have to give a minimum of 30 minutes. If you have a rounding policy at work, please make sure you're not rounding their meal breaks, especially if you have a time clock system that can record time down to the minute or down to the second. It's been a couple court cases. I think the latest one was a Home Depot case, if I'm not mistaken, where employees were clocking out for lunch at like 12 o'clock and 30 seconds and clocking back in at 12:30 on the dot. That's not exactly a 30-minute net meal break, right? That's a 29-minute, 30-second net meal break, so they were not getting their full time. So, make sure that you are not rounding if your time clock gives you the ability to record to the hour. And, any kind of violation, if you don't let an employee take their meal break on time or their regular break, that should be accompanied by a 1-hour penalty at a regular rate of pay. Now, if the employee skips it on their own, make sure you document that. Have some kind of documentation that the employee signs that says, hey, I skipped my break. It was on me. It was on the company. I was allowed to take my break. I skipped it. All right. Make sure that you're doing that. For meal breaks, we always recommend, have as part of your policy that they have to take a meal break based on their hours worked. Failure to do so, if they choose to skip it, say, fine, you chose to skip it, we're not going to pay the penalty. However, it is a violation of policy, so we're going to enforce that. Now, when it comes to overtime, of course, very clear. It's time and a half for any time worked over 8 hours in the workday, and for any time worked over 40 hours in the work week. So it's either one. If someone says, well, this employee worked 9 hours one day, but they only worked 18 hours total for the week, do I have to pay them overtime? Well, yeah, they went over 8 hours in the day, so that's 1 hour of overtime. So again, it's for any time worked over 8 hours and for any time worked over 40 hours. Now, again, remember I mentioned earlier defining what your work week is. That's important because on the seventh consecutive day of the work week, not the seventh day in a row, seventh consecutive day of the work week, the first 8 hours are overtime, and any time after that is paid at double time. So again, that's why it's so important to make sure that we are defining our week, what our work week is, because that's going to have an effect on overtime and on double time as well. And your handouts, you'll also see what an accurate wage or an example of an accurate wage statement. These are the elements that should be present on your wage statement or your check stub that you give employees, right? And this is very important because again, an inaccurate wage statement presented to a lawyer, that's going to give them something to go off of right off the bat. That's a quick violation right there. Once they see that, they could hold on to that and they can start they could start digging in further from there, requesting employee records, requesting other wage statements, requesting payroll records, that sort of thing. That just exposes you to more issues, right? So make sure that you have that. Now, question popped up. No such thing as stupid questions, by the way. What is the difference between the regular rate of pay versus the hourly rate? So the hourly rate is what you told the employee that they're paid per hour, right? You hire somebody on at minimum wage, they're making $16 per hour. The regular rate of pay can be different if you do things like non-discretionary bonuses, or if you have like a shift differential for working the night shift, right? If you have the shift differential for working the night shift, that's like an extra dollar per hour. That is going to affect how much they're really earning, and that, so technically, if you're paying them an extra dollar an hour for any time worked on that shift, they're not really making $16 an hour, they're making 17. So the regular rate is $17 an hour. Now, the important thing about regular rate of pay is that's what's used to calculate overtime. That's what's used to calculate those meal and break penalties and that sort of thing. And for the most part, if you don't have any kind of shift differential, if you don't give any kind of, attendance bonuses or production bonuses or anything like that, your regular rate is going to be your hourly rate, right? But once you start adding those other things on that kind of vary based on the employee either working a specific shift or hitting certain preset goals or preset marks, then that is going to make the regular rate higher than their hourly rate. So a little bit of a convoluted question, but you know, that sort of thing. Now, next one popped up as far as taxes, are bonuses taxed at the same rate? Um, from my understanding, usually bonuses are taxed at a higher rate. There's also a higher rate for things like vacation payouts as opposed to taking regular vacation, that sort of thing. I would recommend ask your payroll processor, payroll provider, accountant for that one because there is a difference as to how bonuses are taxed and how vacation or other kinds of payouts are taxed as well. All right, moving on to our next one. We have independent contractors. That is the misclassification of independent contractors can also be very troublesome now. We get calls from employees from employers all the time that told us, hey, I'm going to hire a 1099 employee. It's like, that's great. What's that mean? Well, I have, you know, 10 line cooks that work for me. And this other one, he just wants to be paid, as a contractor, but he's going to be doing the same thing as everybody else. Honestly, if they're going to be doing the same thing as everybody else, they're not exactly independent contractors. The reason for that is because California said in order for somebody to be an independent contractor, um, they have to meet a 3-part test or the ABC test. And these 3 parts are they have to be free from the control and direction of the hirer, they have to perform work outside the usual course of the hiring entity's business, and they have to be engaged in the trade, occupation, or business of the same nature as the work performed. Well, what's that mean? Well, that means that, say for instance, you are a doctor's office and your sink backs up, so you're going to hire a plumber, right? You hire the plumber, you bring him in, you're paying them for the job. You're not telling them how to do the job. You're not giving them specific instructions. You're paying them to come in and fix a sink. That's it. So they give you a bid for the total cost of the job. You're going to pay them for the total project. Now, again, you're a doctor's office. They're a plumber. Their work is outside the usual course of business, right? You're not hiring in you're not a contracted nurse to do the same work as your other nurses, right? It's someone that does work that is outside our day-to-day course of business. And again, this plumber, we're bringing them in to work as a plumber. We're not hiring a plumber to come in and do work as a receptionist, like our other receptionists. We're hiring a plumber to come in and do work as a plumber. Same trade or nature as the work performed. So again, very important. If you're going to hire an independent contractor or you think someone's an independent contractor, take a look at that ABC test, that 3-part test, make sure they meet that. If you're not sure, again, consult legal counsel on that one because they'll be able to protect you from the exposure on that and keep you out of trouble. All right, the halfway point. Harassment in the workplace. We know it's an ongoing issue. That's the reason California mandates training every 2 years for both employees and for supervisors. And we'll talk about who that applies to. That's for any business with 5 or more employees, right? So again, the important thing is, trying to keep a professional, respectful work environment, right? That's the important thing. That's going to go a long ways in helping that. So again, we want to make sure that we have a policy for harassment prevention, one that lists, protected classes, one that talks about our expectations for that behavior, as well as, how to report it and what's going to be done to correct it, right? Now, again, it's this requirement applies for anybody with 5 or more employees. Um, and again, that's every 2 years. If you have 5 or more employees, your employees must be trained every 2 years. Employees take a 1-hour training, supervisor a 2-hour training. It can be, a live person doing it, or it can be a virtual training, but it has to be interactive. It's not just a video that we play and walk away and call it good. There's got to be a little bit of back and forth, whether it's questions or conversation or whatever it is. If you have a new hire, they have to be trained within 6 months. If you hire a seasonal employee, guess what? You can just say, well, I'm going to hire seasonal for only 5 months and 10 days. I don't have to train them, right? Not necessarily. If they're a seasonal or a temp, and you know they're a seasonal or a temp, you have to train them within 30 calendar days or within 100 hours, whichever comes first. So our advice to you is for new hires, make that harassment training a part of the orientation process. Now, when it comes to investigating harassment, thing to keep in mind is that the state of California is going to hold the employer responsible if they knew or should have known that harassment was going on. What's that mean? Well, that means that you as a business owner, if one of your supervisors is made aware that there's something going on and they don't tell you, guess what? You can't defend yourself by saying, well, my supervisor never told me, because the state's going to say, well, that supervisor works for you. They're an agent of your organization. So by them knowing, in our eyes, the organization should have known and is responsible. So be very careful of that. Again, it's important to train our supervisors, managers, foremen, whatever it is, anybody that's in charge of people, to know what to do in these cases, to at least have them escalate the issue up to HR or to, management or to you as an owner, so you're always aware. Other than that, a few other triggers, to keep in mind. If you observe anything going on, do something, investigate any unexplained changes, any administrative, issues. So if you get a letter from a lawyer's office or from the state telling you that there's been some kind of accusation or charge filed against you, you better drop everything and start investigating, because things can get pretty hairy there. So again, take a look at this. There's a great slide that I always recommend to give to new supervisors and new managers, because that kind of gives them an idea of what to look out for and when to raise the flag if something's going on out there. All right, next one, updating our employee handbooks. So The handbook should basically be the first place your employees go with any kind of questions, right? It's a good reference guide. So it should, not saying it should encompass every single little detail of your business that, tells people what the combination is to the, door lock in the bathroom or everything like that, but it should be a good first reference for them to go. And this should apply for all your employees, right? So again, want to make sure it sets a positive tone and lets them know what the expectations are when it comes to behavior, when it comes to, harassment, discrimination, that sort of thing. We're setting those expectations, we're setting the bar for employees. They can ask any questions beyond that, and hopefully they're asking questions and talking to you about those policies in that handbook, but that handbook should be the starting point for them. And again, some required policies that should be in your handbook, that harassment prevention, lactation accommodation, any mandated leave of absence that applies to you. For instance, disability, California Family Rights Act, FMLA if you're big enough for it to apply, and paid sick leave. Some recommended ones, of course, overtime, vacation, holidays, that sort of thing. Again, those are good ones to have in there because that handbook should be the first place your employee goes with any questions. All right, we're winding up here. We're down to our last three ways to stay out of court. And again, insurance, right? Workers' compensation required for employers in California. So it's not one of those things where you just want to sign up for the cheapest one or find one online and go from there, right? Workers' compensation is really a partnership. Even before you have an employee that gets injured, you want to establish that partnership with your workers' compensation carrier. Use them as a resource. Do they have any trainings they can provide for your employees? What are their processes? What's their reporting process? What are their preferred clinics or doctors nearby? That sort of thing. Get to know them. Don't just sign up for the cheapest one, file it away, and hope you never use it, right? It's a resource. You're paying for it. Use it to the maximum extent. Other policies you can have or other insurance. There's also what's called employment practice liability, which protects you against claims made by employees, former employees, potential employees, that sort of thing. Again, talk to your work comp insurance carrier or your insurance broker if you find that you may run that risk, or you've been burnt there in the past, or you think that it would just bring you peace of mind to have that extra liability insurance. Talk to them, see what they recommend and what they have for you. All right, number two, and this one falls, kind of goes hand in hand with our handbooks and with our management, right? That's using effective discipline and documentation. If there's one thing that I would tell new managers, new supervisors, new leads, whatever you want to call them, it would be document, document, document. Always document everything. Any conversation, even if it's just a coaching, right? Even if it's a positive conversation, shoot an email to HR or to your boss or to yourself, just documenting it so you can refer to it later. Now this becomes very important if it's a coaching where you're dealing with an issue and you're just verbally coaching employees. And then when it comes time to write them up, you say, okay, well, I've talked to you 5 times in the past, and they'll say, well, no, you didn't. Prove it. Well, if you don't have any kind of documentation, it's kind of hard to prove, right? And documentation can be very simple. One trick that I always recommend is if you talk to somebody about an issue, follow up with a quick text or an email. And it doesn't have to be, very detailed or anything else. Just say, hey, thank you for taking the time to talk to me. As a reminder, these are some of the things that we talked about today. We talked about your attendance. Please let me know if there's anything we can do to make sure that you get to work on time. You know, Otherwise, you have any other questions, let me know and send that off. Seems simple, seems courteous, but guess what? You just put a timestamp on that conversation. You just proved that it happened. And if it keeps happening, you can build on that to follow the steps of your disciplinary process. So again, documentation is so important in those cases. So the other thing is, if we're making any kind of work-related decision, make sure that they're based on work factors only. Focus on performance. You know, Focus on those behaviors, those issues at hand, right? You know, is it performance? Is it attendance? Is it a safety violation? Is it a violation of company policy? That's what we're focusing on. We're not focusing on, if someone's slow, we're not saying, well, they're too old for this, or, they can't lift this because they're a certain gender, or whatever it is, right? Just focus specifically on those work factors. And always keep in mind, protections in California, there's several protected classes, right? and they keep expanding. Reproductive decision making is a fairly new one. Off-duty offsite cannabis use, with very few exceptions, any off-duty offsite cannabis use is protected in the state of California now. So you can't terminate somebody because, you saw a picture of them on Facebook and they were, lighting up on the weekend or something like that. It's a whole different ballgame now. There's a lot of protections for employees. Make sure you're aware of them. Make sure you're working with your management team, with your legal team, with your workers' comp and drug testing clinics to make sure that you are compliant and everything, everything's up to snuff. So things you can do, of course, focus on the work, right? Focus on the work in the workplace. That's our important thing. What they do on their own time, unless it's bleeding into the workplace, we're not going to think about that. We're going to focus on the work. We're going to make sure that our harassment policies and any policies for that matter are enforced accurately, fairly, and consistently across the board, right? Again, we're not gonna, it's an election year this year. There's gonna be a lot of discussions, around politics and that sort of thing. Keep an ear out, keep an eye on those conversations because they can very easily bring in other protected categories, whether it's national origin, gender, race, that sort of thing. Those can very easily be brought into those political conversations, and be either seen as or actually be harassment of somebody. So again, keep an eye on those conversations. I'm not saying, ban them or prevent them from happening. Just make sure that you are outlining your expectations for that respectful interaction between employees. Okay, when it comes to discipline or disciplining employees, again, consistency. Make sure you're consistently applying those policies. Make sure employees know what the expectations are. Make sure that they are clear on what the expectations are, right? We're not surprising anybody. Someone breaks a rule. They knew what the rule was. They knew very well that they could get in trouble for it. They got caught. They should not be surprised for that. Again, be very, very careful with that. And our last one, since we're winding down today here too, is, we started with hire slow. Now we're going to end with fire fast. And by fire fast, I don't mean just walk into the workday one day and, just start letting people go. You're fired, you're fired, you're fired, you're fired. What I mean by fire fast is when it comes time to end that employment relationship, when it comes time to let somebody go, don't dilly-dally. If all your ducks are in a row, move them on out, right? If we have, all the documentation we need, if we have the final check, if we have everything, everything that we need, and that decision's been made on Monday, don't wait until Friday because you don't want to do an extra payroll run or because you don't want to cut an extra check or whatever it is. Because from Monday through Friday, there's a lot of things that could happen between there. They could put in, you know, for a protected leave of absence. And all of a sudden, if they put up for a protected leave in the middle of that week and you let them go, it's going to look retaliatory. Or they could get injured between that time. And guess what? Then even if you do let them go, you still have that workers' comp case hanging over your head. So again, once the decision is made, once you have everything in place, everything's lined up, everything's justified, let them go. Don't hang on too long. And of course, as with discipline, termination should not be a surprise, right? By that point, you've established the expectations. You've probably had conversations a couple times regarding that issue. When it's time to let somebody go, let somebody go. In your packet, you'll find a list of required forms too that should be there at termination. Of course, the big one is that EDD for your benefit pamphlet. Used to be a little blue booklet. Now you can just print it out off of the internet, right? Any COBRA information, notice of any kind of any kind of insurance notification, that sort of thing should all go with it, along with the notice of change in relationship. And that's just the termination form, right? That just tells them on what day is their last day of employment and the reason for termination, policy violation. Boom, that's it. You give them a copy of that, keep a copy for the records. That way, if there's any discrepancy, if they apply for unemployment or anything, you have that documentation right there that you can use as backup. Now, very important too, when it comes to terminating somebody, make sure that you're paying them correctly and in a timely manner. So if you're letting somebody go, if you're terminating somebody, the minute that those words, you're fired, we're letting you go, we're ending your employment, whatever it is, leave your mouth, you should be ready to hand them their check for all hours due up until that point. So any vacation, unused vacation they have, all the hours worked at that time, whatever it is. If somebody quits, that's going to vary. So if they quit and they give you more than 72 hours notice, if they come in on Monday and say, hey, my last day of work's on Friday, I've had enough of you, then when Friday rolls around, you better have their check ready with all their pay because they gave you more than 72 hours notice. Now, if somebody walks in Monday morning and tells you, I'm done, I'm walking out right now, you have 72 hours from that point to pay them all their hours owed to them, all their time owed to them, right? So again, that 72 hours, that is for that voluntary termination, that voluntary resignation. So now, as far as mailing the check, do not mail that final check unless they ask you to. And if they ask you to, get that in writing. Have them verify their address. Because if you don't, and if you mail it without asking, that check gets lost or their dog eats it or the mailman loses it or whatever, you could be on the hook for waiting time penalty. So be very careful with that. So again, for terminations, if you're letting somebody go, make sure you have somebody in the room with you. Get somebody in the boat with you, right? Have a witness. That way, if they refuse to sign any forms, you just say employee refused to sign and you have a witness there. If somebody resigns or somebody's, leaving, get it in writing. Doesn't have to be a full, 2-page resignation letter. Just let them know what the last day is. If they want to have the reason why, go ahead. If you got to do an exit interview, that's on you. And of course, we have a termination checklist available for you if you want to use that to make sure that you're covering your bases there. So some takeaways for you for today, since we're right at the hour. Take a look at your internal procedures, make sure that you're compliant. Train your supervisors and managers to make sure that they know the policies and they're following them, right? Your frontline managers and supervisors, they're going to keep you out of trouble. They're the ones that are going to keep you out of trouble. Unfortunately, they could also be the ones that get you in trouble. So make sure they're trained, they're knowledgeable. And if they don't know, make sure they're confident enough to know who to ask. Have that open door policy. Make sure your policies are clear. And of course, update that employee handbook at least once a year. Usually beginning of the year is a good time, or end of the year. That's when you know what laws are taking place. So with that, we're right at the hour. I don't want to take too much more of your time. Just want to remind you of the complimentary hotline brought to you by Ventura County Workforce Development Board, 888-763-3174. Give us a call with any questions. I saw there was 1 or 2 questions floating around there. One of them was very specific to a business, so please give us a call at the hotline so we could talk through it. If you want anything beyond, the hotline, we do offer memberships, everything from relative membership down to a monthly associate membership. So take a look, do offer some more advantages for being members. Now, if you want to spend some time in Tahoe, we also have the California Nevada Employers Summit coming up. We're teaming up with the Nevada Employers Association too, having a great, was it half day seminar, I believe, Anna? Up in lovely, lovely Tahoe. We're going to talk about, you know, the differences in California, differences in Nevada. So if you're a business that kind of goes, works at the border or has employers in both areas, come join us. We'd love to see you there. If you're with us for continuing education, I do have some codes for you. For HRCI, it is 674665. And for SHRM, 24-95YAA. And if you've seen me present before, I always say, do not forget that dash for SHRM, or they will be very, very upset. Well, at least they won't give you credit. Anna mentioned that survey for you, so I don't want to make a liar out of her. Here is the screen for you. Take a shot with that on the phone. Let us know what you liked about today's presentation, what you didn't like about today's presentation, or what you'd like to hear about. So it's a very short survey. Let us know. Again, I'd like to thank the Ventura County Workforce Development Board. Roxana, thank you very much to you and your team. Anna, if you want to wrap us up, we'll call it a day and let these fine people carry on.
I mean, I think you covered everything. I think the only thing that I want to draw attention to is one, if you have not put your business name into the chat to help out our partners over at Ventura County to really account for the breadth and scope of the employers that they are able to help with these trainings. This allows them to help secure funding in order to continue to provide these trainings as well as other resources. So if you have not done so, please provide your business name in the chat. That's all the information that we really need right now, just so that they can provide those in their record. So we'd really appreciate that. Second thing I want to draw your attention to, if you scroll up in the chat, just a couple of messages. I did put the next training coming up September 24th. It's about time management, and who doesn't love more tips about that, right? So we're going to focus on it the SMART goals way. And again, this is the next free training sponsored by our partners over at Ventura County. So we really encourage you to take advantage of that. That's coming up September 24th. So with that, I really want to thank Roxana, Cynthia, Colleen, the entire team behind the scenes over at Ventura County Workforce Development Board. And thank you all for joining us live. Thank you, Eli, for sharing your time and expertise today. By the way, you guys had some really, really good questions. I really love to see such an engaged chat and Q&A box. So kudos to you for coming to today's training, ready to ask your questions and get some resources. If you, for some reason, need more resources, please do call that HR hotline. That's what we're here for. That's what Ventura County is providing it for. So we look forward to seeing you on the 24th, and we'll see you soon. Thank you all.
Thank you.
Thanks, Roxana.